Good afternoon, and thank you for joining us today for the third webinar in Sterne Kessler, Goldstein & Fox's P.T.A.B. 5th Anniversary Series, 5 years at the P.T.A.B. Federal Circuit Review of AIA Post-Grant Proceedings. Allow me to introduce our speakers. Michael Joffre, a director and co-chair of Sterne Kessler's appellate group, focuses his practice on intellectual property disputes before trial in appellate courts. He has briefed and argued matters in jurisdictions throughout the country, including Texas, California, Wisconsin, Delaware, the U.S. International Trade Commission, the U.S. Patent Trial and Appeal Board, and the Federal Circuit. Mr. Joffre has also represented clients before the U.S. Supreme Court at both the certiorari and merits stages. John Wright is a director who co-chairs Sterne Kessler's appellate and PTO litigation practices. He focuses primarily on contested proceedings before the U.S. Patent Trial and Appeal Board and on appeals of those cases to the United States Court of Appeals for the Federal Circuit. He is familiar with the challenges faced by both patent owners and petitioners in these complex proceedings, often working closely with trial counsel as part of an interdisciplinary team. Mr. Wright has been lead or backup counsel in over 65 inter-parties review proceedings, mostly on behalf of patent owners. He has also briefed and argued numerous appeals to the Federal Circuit. And with that, I will turn it over to our speakers.
Hello, this is John Wright. I'm here with Mike Joffre. Thanks for joining us this afternoon. Here's our agenda. Mike and I are going to start off talking about key cases pending before the Supreme Court, namely the Oil States case and the SAS Institute case. We're then going to turn to two en banc cases at the Federal Circuit, the Aqua Products case, which just issued, and the Wi-Fi 1 v. Broadcom case, which is still pending. Then we're going to turn to an analysis of remanded and reversed cases coming from the Federal Circuit on review of cases coming out of the P.T.A.B. We're going to pause there for some Q&A to break things up a little bit. And then if we have time at the end, we're going to cover some Federal Circuit statistics for P.T.A.B. trial reviews. It's a lot to cover, but we're optimistic we can get through a good portion of it. So without further ado, I'll turn it over to Mike. He's going to cover the Oil States Energy Services case.
Right, and to be clear, all of the, or a large chunk of the cases that we're going to talk about today, you could have an entire webinar just on that case alone. So we're necessarily going to be pretty brief, but hopefully this will highlight the state of both the most important cases that the courts are dealing with regarding the P.T.A.B. proceedings, and also give you a gist of cases and flavor kind of cases that the Federal Circuit is troubled by and is most likely to remand or reverse on. But before we get to that, as John said, the most important case, obviously, that concerns P.T.A.B. practice is Oil States. And the reason being is that Oil States could blow the whole thing up. Oil States, for people that are unaware, is currently a case that was granted cert by the Supreme Court and set to be argued very soon. We have most of the briefing. Obviously, we don't know which way it's going to come out. But the background of it is the following, is that the patent owner essentially argued throughout that IPRs are unconstitutional. And their flavor of why they think it's unconstitutional changes a little bit depending upon which brief you look at. But essentially the point being is that they say, look, patents are private rights. They are pieces of property like any other piece of property. And therefore, under the Constitution, the only body that is allowed to consider and adjudicate and extinguish those private rights would be an Article III court. What you're not allowed to do is, just because you don't like the way Article III courts are ruling on something, is give that power to a administrative agency or an Article I tribunal. So, that can be followed on from that point that this is a private right that requires adjudication in an Article III court, is also the point that these are the types of rights that have always been adjudicated or were traditionally adjudicated in front of a jury. And so if you're going to extinguish the property right, then the only way that you can do that is via a jury. This is obviously an enormous, would be an enormous win if the Supreme Court sided with them. Obviously, they have both the private party, the petitioner, and also the government on the other side saying this is all right. And the main argument to the contrary is essentially that patent rights are public rights. And this private right, public right distinction can be a little nuanced. But the point of it is that when you have a regulatory regime that is extremely comprehensive and that bears directly on the issue, then the government says you don't need to have an Article III court to adjudicate a right that comes out through that regulatory regime. Namely, they would call it a public right. And the central analysis is that if the right is so closely integrated into a public regulatory scheme, then it makes sense for the agency that is taking care of that or governing that regulatory scheme to be the one that adjudicates the right. And in this instance, the government argues, the PTO obviously has a very special expertise. They are the ones that grant the patent in the first instance. They're the ones that have the specialized knowledge as to when patents should be patentable and not patentable. And so therefore, the government argues is that it is extremely, or makes a lot of sense for the PTAB to be the one to take a second look at the patent, because it is integrally related to the regulatory scheme of the patent issuance in the first place. And so because it falls within the scope of this public right distinction or this public right grouping, Article III courts are not a requirement under the Constitution. This is going to be fought back and forth quite strongly. It's already been fought in a lot of the briefing. Obviously, the oral argument may be telling. But ultimately, the question is going to be how much do we think of a patent as being like a piece of land, like a thing which one can, possess and own, and how much do we think of it as a creature of statute that is government-blessed monopolies that are given in exchange for the inventor conveying the information to the public. And I think that distinction is what's going to eventually, at least, I don't know if the Supreme Court obviously will decide it along that distinction, but that's certainly how it will likely be argued. And I think that no matter what the outcome is, and particularly if the court decides that IPRs are unconstitutional, I think the ramifications are going to be quite large. They are going to be, they will get out not only PTAB proceedings, but by the said token, it's not clear that there's any way that any logical distinction why they would not, for example, impact standard ex parte re-exams. Not clear why they would not affect, for example, the ITC proceedings. So there could be a lot of fallout of this. And if, on the other hand, the court says, no, this is a public right, and this is all okay, then we may see congressional action that decides to even go farther and decide more things are public rights, or there's more ways that that take sort of some of the power out of the Article III branch. So with that, everyone's going to presumably be most interested in that, but the other Supreme Court case that John's going to handle is SAS Institute.
Great, thanks, Mike. So if there's a day for patent practitioners to go sit in on Supreme Court arguments, it would be November 27th, because both these cases will be argued that day. In SAS Institute, so what's this case about? It's about the interpretation of 35 U.S.C. Section 318A, which provides that the PTAB, in an inter partes review, and I'm going to quote the language of the statute, shall issue a final written decision with respect to the patentability of any patent claim challenged by the petitioner. Under current board practice, the board it institutes inter partes review on a claim-by-claim basis after considering the petition and any patent owner preliminary response. And it is not unusual for the board to institute a review on a subset of the originally challenged claims. Further, when the board thereafter conducts a trial on that subset of claims, its final written decision typically addresses only those claims that the board instituted trial on, those claims that were selected for review. And in this particular case, SAS Institute, there was a split decision from the board following a partial institution. So what you have is, in this case, is the board invalidated 8 petitioned claims. It validated 1 petitioned claim and simultaneously ignored 7 other petitioned claims that were properly presented for review. And the software developer here at SAS Institute challenges the PTAB's position that it can pick which patent claims it will issue final written decisions on when it conducts its IPR reviews. And according to SAS, the statute unambiguously requires a final written decision on every challenged claim, irrespective of whether the challenged claim was selected for the trial phase of an IPR proceeding or not. So why is this important? Three reasons, I think. First, the case would have major implications on the estoppel provisions. Under Section 315E2, which governs the estoppels that apply to a petitioner is estopped from arguing that a claim is invalid, both in district court and in the ITC, quote, on any ground that the petitioner raised or reasonably could have raised during that inter partes review. But the estoppel only applies where there has been a final written decision under Section 318A. So, since the estoppel is applied on a claim-by-claim basis, for the claims where the board decided not to institute review, no estoppel applies. And the petitioner, presumably, would be free to challenge those claims in both the district court and the ITC. And if the Supreme Court overrules this, it would change that calculus. Now, that's the primary reason why, or the primary impact that this case could have if the Supreme Court overturns the Federal Circuit, which sanctioned the current board practice. Now, what SAS is arguing, and the second reason why this is important, is that the Patent Office's current practice departs from and negates the intended legislative purpose of the AIA, which was to provide a cheaper and more efficient venue for addressing patentability with the goal of reducing patent litigation. And this case presents kind of the perfect fact pattern where the board's split decision following partial institution leaves a muddled mess and adds uncertainty, especially because the full scope and impact of the estoppel provisions are still being fleshed out in the district court. So Judge Newman has dissented in a number of cases that have challenged this proceeding, and it's likely that at least a number of members of the Supreme Court, at least 4, think that the Federal Circuit's sanctioning of current practice is suspect. The final reason why it may be important is that SAS says the Patent and Trademark Office is not entitled to any deference because the AIA clearly, in its view, states that the board must write final written decisions on all challenged claims. The Solicitor General's Office, representing the Patent Office, maintains that the PTO is entitled to Chevron deference. So this could be yet another case coming out of an agency that has the potential of impacting Chevron deference, which I'm not a Supreme Court expert, but there are a number of justices that question the continued validity of Chevron and the deference that courts give to administrative agencies under that case. One more unintended consequence that may come out of SAS v. Mittal is, would the non-instituted claims be eligible for appellate review even though there was no trial? If that's the case, then that would work in the petitioner's favor, and for claims that were not instituted, petitioners might very well get the Supreme Court to take a second look at that decision. So that covers the 2 that are pending at the Supreme Court, again, both being argued in November, and I think the Patent Bar is going to be waiting on pins and needles for the court to issue decisions in those cases. So now we'll turn to the en banc cases, and so that we get a change of voice here, I'll turn it over to Mike, and he'll discuss Aqua Products v. Mittal, which just issued, I think, last week. And then I'll talk about the Wi-Fi 1 case, which was argued in May, but we're still waiting on a decision there from the Federal Circuit.
Okay, the Aqua Products case is extremely interesting, only because of the sheer amount of pages of opinions it generated. It's just an incredibly large number of opinions that generated this very strange 5-2-4 split with concurrences and overlapping analysis. So that ultimately it becomes very difficult to see exactly where the court's heading, and that may trigger, therefore, potential cert issues that could be resolved by the Supreme Court. The question in this case is essentially who has the burden of proof to amend claims during an IPR. What this turns upon is an interpretation of a statute that provides nominally the burden of proof. It's 35 U.S.C. 1316D. And that statute says that the burden of proving a proposition of unpatentability is on petitioner in IPR. Now, everybody agrees that if, as to claims that came in originally through the petitioner bears the burden. But the court was faced with the question, well, who has the burden of proving unpatentability of an amended claim? And like I said, it was split quite a lot. What Judge O'Malley's opinion, which is sort of placed as the majority opinion, is that she believes that it's unambiguous, that a proposition of unpatentability means any proposition of unpatentability, including whether or not an amended claim is patentable. And so, therefore, because the statute's clear on its face, that should be the end of it. No more deference, and that's the answer. Unfortunately, the majority of the court disagreed with her. So she's not only writing the opinion for the court, but but the majority of the court actually found that the statute was ambiguous. They said that it's not at all clear whether or not the proposition of unpatentability covers an amended claim. And Judge Toronto provides sort of the strongest argument for that, which is the point being that if a petitioner decides that he doesn't want to oppose an amendment, then there would be no one essentially arguing against or raising a proposition of unpatentability as to the amended claim.
Yet the PTAB would still have to write an opinion, a formal decision saying whether or not the claim, the amended claim is patentable. So that leads to a problem which they claim makes the statute ambiguous, et cetera. Ultimately, what a majority of the court finds is that even if it's ambiguous, though, there's no rule that the PTO has not said in a clear way or promulgate a rule in a clear way of who should have the proposition, or who should have the burden of proving patentability for an amended claim. There is a sort of general rule that talks about whether moving parties for any sort of generalized motion has the burden of proof of establishing that they're entitled to the request for relief. But that did not speak to burdens of proof as to patentability. It did not address it really. So therefore, there's really no clear statement by the PTO that deserves any deference on this point, and so therefore there's nothing essentially going the way that the PTO wishes that it did. Now, what that means ultimately is right now we're in a place where the petitioner has the burden of proving patentability. Or unpatentability of any amended claim, and furthermore, the PTAB has to look at the entire record in order to make that decision. It doesn't just look at the face of the motion. But it seems fairly clear that a majority of the court may well find that the PTO could flip that presumption, that the PTO could hold a normal NPRM rulemaking and decide to have a clear rule saying who bears the burden of proof, and say, for example, put it upon the patent owner. And in the end of the day, such a rule, if it complied with the requirements, would presumably pass muster under Chevron for at least the majority of the court. And so therefore, because the PTO would have spoken in that instance, clearly there's some chance that we're going to see this all cleared up via rulemaking. Now, of course, there'll still be the fight that 316D says what it says, and the PTO can't violate that. But it seems right now that we're on a place where at least the majority of the Federal Circuit would think that would be okay. So we'll see. There's a lot of possible actions that can come out of this, and this was just decided, so it's worth keeping track of.
Great. Thanks, Mike. I'll add two quick observations to Aqua Products. First, as a practical matter, the court did say in Judge O'Malley's opinion that this applies retroactively to every PTAB proceeding that's pending right now. And we just yesterday, or maybe 2 days ago, saw the first orders from the PTAB granting, or not granting, but effectively extending the 1 year period for conducting inter partes review into that 18-month period that is available for good cause. I'm putting air quotes around that. So apparently dealing with retroactively with this shift in the burden of proof constitutes good cause for the PTAB to extend beyond 1 year its statutory deadline for getting a final written decision out into that 18 months. And the second observation is the confusion ultimately that this case may have engendered lends additional weight to the rumblings that we've heard from the PTAB about creating perhaps an off-ramp from PTAB proceedings where a patent owner wants to amend claims. The PTAB has been talking about potentially having an off-ramp and converting the proceeding into an ex parte re-examination. And of course, if that is the route that the Patent Office wants to go to ensure that this problem that Judge Toronto raised doesn't exist and that these amended claims get examined, then it brings into question, does BRI still apply? Because the sole basis undergirding the office's use of the broadest reasonable interpretation is the ability to amend claims. So lots of, I think we still have yet to see the full fallout of Aqua Products. So turning to Wi-Fi 1 v. Broadcom, this case was argued back in May. So let's see, June, July, August, September, October. We're hitting 5 months. What did it take, 9 months for Aqua Products to come out?
It took a lot of writing, though. So.
Yeah, it took a lot of writing, but we can see why it took 9 months for Aqua Products to come out. And if anybody is, laying bets on how Wi-Fi 1 is going to come out, just take a look at Aqua Products. Think that they've been considering this for 5 months now, and frankly, I'm expecting a decision of similar length and possible confusion. So what's Wi-Fi 1 about? So here, broadly, it's about the scope of appellate review, and the question presented to the en banc court is, should this court overrule Katie's Reference Publishing v. Apple and hold that judicial review is available for a patent owner to challenge the PTO's determination that the petitioner satisfied the timeliness requirement of Section 315B governing filings of inter partes review. Okay, what does that mean? Section 315B puts a 1-year statute of limitations for filing an inter partes review that's 1 year from the time that a would-be petitioner has been served with a complaint alleging infringement of the patent. That's a quote, served with a complaint alleging infringement of the patent. So as soon as you're served with a complaint, you have 1 year to file your petition. And here Wi-Fi argues that the petitioner Broadcom was in privity with entities involved in a parallel district court litigation involving the challenged patents, and that because Broadcom was in privity with those parties, Broadcom did not meet the 1-year time bar under Section 315. The PTAB in this case rejected Wi-Fi's arguments and call for additional discovery on the issue, and they held that the privy requirement could only be met if Broadcom had the right to control the district court litigation, and ultimately determined that it did not. So when that issue came up on appeal to the Federal Circuit said, at least in the panel decision, said that Section 314D, which prohibits appellate review of institution decisions, precludes review of this whole Section 315B 1-year statutory bar issue. Wi-Fi 1 sought en banc review, and it was granted, hence this case. So this case sits in the shadow of the Supreme Court's decision in Cuozzo. There, the Supreme Court foreclosed review of institution decisions where the question kind of sits directly in the PTAB's wheelhouse, like, did you meet your burden to show unpatentability of at least one claim? But it left open the question of how far Section 314D reaches. 314D being the part of the statute that says institution decisions are not reviewable. And it said that these questions of interpretation that are closely tied to the application and interpretation of statutes related to the Patent Office's decision to initiate an IPR are not reviewable, but that constitutional questions that depend on less closely related statutes or that present other questions of interpretation that reach in terms of scope and impact well beyond this section might be reviewable. So the Federal Circuit has to decide the scope of review question in the context and under the Supreme Court's guidance in Cuozzo. So what's at stake? Broadly, the scope of appellate review. Certainly, if the issue of the Section 315B statutory bar is reviewable on appeal, then I think appellants want to test the limits of that ruling. And one example that comes to mind is, for example, does the doctrine of asinore estoppel apply in PTAB proceedings? Right now, the PTAB has said that it does not, and the Husky injection case, which came to the Supreme Court, again relied on Section 314D and said we're not going to review that determination. And there are other issues besides privity that are wrapped up in Section 315B itself. For example, 315B on its face doesn't make any exceptions for complaints that are served and filed and then dismissed without prejudice. But the Patent Office has said that, well, if it's dismissed without prejudice, it doesn't count. So that's one issue that could be reviewed. Does the Section 315B statutory bar apply to ITC complaints? Right now, the Patent Office has said that it's not, and the Federal Circuit has had no opportunity yet to review that determination. And arbitral complaints. Section 315B on its face is not limited to a civil action. And there are other places in the statute that specifically call out a civil action. So again, there are issues under 315B itself that I think are ripe for review by the Federal Circuit if it overturns Acades in the Wi-Fi 1 case. So that pretty much covers Wi-Fi 1. And what we're going to cover quickly is standing. There were two very important standing cases that came out this year from the Federal Circuit. And then we're going to turn to an overview of reversed and remanded decisions. So I'll turn it back to Mike for the Phygenics case.
So I'll be very, very quick. Essentially, Phygenics stands for the proposition that essentially anyone can file a petition for an IPR, but if you're going to appeal to the Federal Circuit, you have to have Article 3 standing. And specifically, you have to show an injury in fact. In that case, Phygenics didn't manufacture anything, but it had its own patent portfolio. And so what it wanted to do was get rid of the competitor's patent with the hope that they would get more licensing revenue for their own patents if they were able to do that. The problem is that Phygenics never asserted that. There was no real factual support for that argument. It was basically all attorney argument. And so by the time it got up to the Federal Circuit, there was really no clear reason why Phygenics, or any good facts why Phygenics had been injured at all by this patent. And so the Federal Circuit said dismissal. We don't have the standing to bring suit here in Article 3. In Article 3 court, even though you obviously have the ability to bring a petition in the first instance. So I think all this teaches us is that if you think that Article 3 standing is going to be an issue, then you should get your facts in early and often so that you can avoid worrying about problems, for example, such as injury in fact and other constitutional requirements.
Great, thanks, Mike. I'd be remiss if I didn't mention that it was our partner, Eldora Ellison, that represented Phygenics, Immunogen in this case and got it kicked on the standing issue. I'll be even quicker with personal audio. Personal audio dealt with standing for an appellee that might be in the same situation as Phygenics was, but the court said that with Article 3 satisfied as to the appellant, here the Electronic Frontier Foundation was not constitutionally excluded from appearing in court to defend the PTAB decision in its favor. It's a pretty straightforward ruling. There is at least one patent expert out there that believes that this case was wrongly decided. I saw a contrary opinion by Dennis Crouch in Patently O. And if you are an appellant and you think that your opponent appellee may be standing like Electronic Frontier Foundation does, it might be worthwhile to investigate what Professor Crouch was saying about why he thinks the Federal Circuit got this wrong, and attempt to get that overturned. So Again, two important standing cases from 2017 that we wanted to cover quickly. So we're going to shift gears now to outcomes from AIA appeals, and specifically to cases that have been remanded or reversed, and see what we can learn from those cases. So we're going to start with this overall pie chart. Then we're going to break the remand and reversal cases down into a number of buckets and give you the percentages that apply to each of those buckets for reasons why cases are reversed or remanded. And then I hope you all will find this very useful. We have charts showing every case, or the name of every case and docket number for every case that has been either reversed or remanded by the Federal Circuit for AIA cases. And then Mike and I are going to pick, if we have the time to do it, pick one or two cases from each of those buckets and just give a quick overview or flavor of those cases.
Yeah, I think this is, we say this was important because while we covered the big name cases, the ones that have drawn a lot of attention from the patent bar and discuss those, you can learn quite a bit through looking at the run-of-the-mill cases and seeing what the Federal Circuit's decided to do when it's deciding to remand or reverse. Because as the pie chart shows, basically the Federal Circuit affirms most of the time, and that's still true, although we have statistics showing that is becoming not quite so overwhelmingly true in the last year or two. But there aren't really that many in some sense as remands and reversals by the Federal Circuit. So by looking at those, you can get a good idea of what kind of issues you should be presenting that are different from the big name cases in your own appeals. So with that, I think we first go into the analysis of how these remands and reversals came out in the next chart.
Yep, and just the big picture, you can see that appellants face, at least statistically, an uphill battle at the Federal Circuit with nearly, close to 80% affirmance rate, 76% affirmance rate. Remands sitting at 15% and reversals even more rare at 7%. The 2% that get dismissed, that would be like the Phygenics case, or some cases settle, etc. So here are the different buckets for both remand and reversal. By far the most common reason for remand is the failure of the PTAB to sufficiently articulate its reasoning. Because these are cases coming out of an administrative agency, the agency is bound by the Administrative Procedures Act, the APA, or I think it's Title V, right? U.S. Code. And under the APA and under the umbrella of appellate review from agency decisions under the Chenery Doctrine, the Patent Office has to meet certain minimum standards in its opinions for the opinions themselves to survive appellate review. And because we had such a huge growth in the number of PTAB judges, there are a large number of judges up there that just don't have the experience yet in writing final written decisions that can stand up to appellate review. And Mike probably agree with me that I think drives the failure to sufficiently articulate reasoning here and the high percentage of remands that we get there. Other reasons for remand in order, claim construction can get you a remand where, because claim construction is an issue of law, you can say, oh, the claims were construed wrongly, but since anticipation, for instance, is a question of fact, you often have to get a remand to assess the facts under the new claim construction. That's not always the case, but it's often the case. Procedural violations and other legal error follow at 21% and 13%. And then reasons for reversal. Legal error can get you a reversal, as long as the underlying facts are undisputed and come out in your favor. Claim construction can get you a reversal. There was a very recent case just a couple days ago where claim construction error resulted in a flat-out reversal, and so can procedural violations. So without further ado, I just remind everybody to tee up any questions you have into the chat box. Just type them in there, and we will get to them when we break. So, failure to articulate reasoning. Mike, did you pick a case here?
Yeah. So I mean, these are all very similar in a lot of respects. I chose just one of them. It's sort of exemplary. It's the invasive one that you see there, 15-1610. And this is sort of very standard kind of thing that you see. What the case was that the P.T.A.B. invalidated a patent as obvious in light of two pieces of prior art. And the problem was that the P.T.A.B. didn't explain why one would actually want to combine those two. All it did was rely upon a conclusory assertion by the petitioner's expert that the second reference would provide additional information. And the Federal Circuit said that's just not enough. You cannot, you can't just conclusory state something. You have to have a reasoning that's reasonably discerned under Chenery. And in this case, you couldn't figure out what the P.T.A.B. thought was the reason, or figure out where the P.T.A.B. was going in its decision, because the P.T.A.B. just didn't say anything. And so I think this is a very standard kind of way that cases end up remanded, is when the P.T.A.B. just doesn't do enough. And John has thought about this quite a bit in terms of what to do when you are not the challenger of the patent or the challenger of the decision, the appellant, but if you're the appellee. You know, are there times that you might want to try to seek a clarification or a reconsideration, maybe even, of a decision that you won on at the P.T.A.B. If you're afraid that there's a chunk of the decision that just was not explained. Now, obviously, this is tricky. Winning and asking for recon sounds odd, but the problem is that you may be setting yourself up for a round-trip ticket if you see a chunk of the P.T.A.B.'s decision that just wasn't very well supported or supported at all. It could well go up to the Federal Circuit and then come back down so that the P.T.A.B. has to do it again. Yeah,
that's right. You don't have to lose to request reconsideration of a final written decision. You just have to be, according to the rule, unsatisfied with it. And perhaps the best example here on this list of cases where, well, maybe in hindsight it might have been a good idea to ask for reconsideration are the Securus and Global Telling cases. There, the final written decision, I can't remember which one of those it was, or maybe it was both. The P.T.A.B. decision just simply did not address some of the dependent claims that were at issue. Even dependent claims that were not challenged by the petitioner, but because the board's final written decision was completely silent, the Federal Circuit had no choice but to remand, because it didn't have, there wasn't enough in the opinion where it could even do any sort of appellate review. So, yeah, that's right. Again, strategically and carefully crafted, but if you get a final written decision where you win, but you think it might have serious issues surviving appellate review, consider a request for rehearing. Again,
and remember, this is the one that you actually have to worry about in some sense the most, because this is the single largest reason that cases get remanded back to the P.T.A.B. It's the failure to articulate reasoning. So this is a big one that you have to be aware of. Yeah,
the Cutsforth case, the second one on the list, is instructive. That was one of the very first ones that had a remand. It's non-precedential, but I'll just quickly, the board there followed its typical, or at least it's something we see a lot. The board just says, patent owner argued X, Y, and Z. Petitioner responded X, Y, and Z prime. We agree with the patent owner wins. That's not good enough in a board decision. The board has to say why the patent owner wins. Claim construction remands and reversals. There are two very recent cases that I want to cover quickly. One is not from an IPR, it's N. Ray Smith. The citation is at the very bottom. And then the Owens Corning v. Fastbelt, which just issued a couple days ago. In N. Ray Smith, you have a decision from Judge Lurie that really takes the PTAB to task for using not the broadest reasonable interpretation of the claim term, but the broadest possible interpretation of the claim term. The term was a generic term, body, in a claim, and the board just went way too broad with the term body and had that include other elements that the specification called out as being different, like a mandrel or rotating arms or other things. And the board, the Federal Circuit said you went too far here. Broadest reasonable interpretation is not the broadest possible interpretation, and you have to do more than just show that the interpretation is not inconsistent with the specification. Under that logic, Judge Lurie said you end up with the broadest possible interpretation. You need to make sure that the construction is consistent in light of the specification. And that's the way to do claim construction. But for every case that kind of cuts back on BRI, the Owens Corning case, which just came out, there was an implicit claim construction issue. So the court construed the claim one way explicitly, and then found that all the elements of the claim are in the prior art. But when it came to analyzing the motivation to combine, which the PTAB found was not present and consequently confirmed the claims, the appellant's argument was that, well, when the PTAB looked at the motivation to combine, it implicitly put some limitations back into this claim term that are unwarranted and inconsistent with the way the court expressly construed the claims. And the Federal Circuit agreed. And this is one of those cases where the Federal Circuit said, no, you went too narrow here in this analysis. You can't construe the claim one way for finding elements in the art and then another way when you look at the motivation to combine. And the court said, oh, you implicitly went too narrow here, and under the broadest reasonable interpretation, this is unambiguously, there would have been a motivation to combine, and the court reversed, not a remand, but reversed the board's patentability decision. So there are two recent cases, both instructive, that kind of cut both ways on claim construction. Mike, did you pick one for procedural violations?
So these are listed under procedural violations. Ultimately, I mean, these all can be thought of as ways in which the PTAB was unfair in its process. And you know, a lot of times these are sort of very specific and you know, to the procedure that was actually employed in a given case. But essentially, they're there to illustrate that you just have to look out for cases where what the PTAB did seems unfair and contrary to the APA. So an example of this would be the Emerchem Holdings, which is was just decided last June. In that case, the PTAB instituted an IPR on obviousness grounds. And in the petition and in the institution decision, one of the claims was found or was instituted as being obvious in light of one reference, and a second reference was used for other claims. The Stiles reference was used for other claims, but for some of the claims, only one of the references, not Stiles, was used. When it came around to the final written decision, however, the PTAB found that those claims were invalid in light of Stiles, and so the patent owner rightfully complained that they had no notice that Stiles was going to be used to invalidate these claims. There was nothing in the institution decision, there was nothing in the petition, and while it was true that the Stiles reference was generally discussed throughout the petition, and generally discussed throughout the institution decision, the petition and institution decision, that there was nothing specific there, and so how could they know what they were fighting? It was just unfair. And the Federal Circuit agreed. They said that the APA requires the PTAB to inform the patent owner of the matters of fact and law asserted, and in this instance, there was simply no clear indication or any reasonable indication to the patent owner what the actual grounds were going to be that were ultimately found to make the claims unpatentable. And so the Federal Circuit sent it back because you can't just have a vague generic reference to reverse saying you just can't have a vague generic reference to a prior art reference and claim that's good enough for all purposes. So that's just sort of one example of how there may well be some sort of procedural issue, especially as and we've sort of seen this come up sort of lately as the procedures are being shaken out at the PTAB.
Great, thanks, Mike. I know that we are 50 minutes in, and those of you that are listening at your desk and digesting your lunch might be tempted to nod off. I want to urge you all to pay attention to the Ultratech v. Caption Call case. It's the second one from the bottom here. It's a very interesting case. It's an excellent decision by Judge Moore, and it is the first Federal Circuit case that I'm aware of where the Federal Circuit takes the board to task for the way in which the board deals with evidentiary issues that arise during the course of a trial. If you are in-house counsel and you are supervising IPR petitions, you need to pay close attention to this case. Here, Ultratech and Caption Call had just finished litigating a district court case, and the patent owner Ultratech had secured a $44 million verdict against the petitioner Caption Call. And 5 months after that $44 million verdict, the board came out with final written decisions saying that all the patents were invalid. And during the course of the trial, in fact, near the end of the IPR trial, the patent owner Ultratech moved to supplement the record. What it wanted to do was get in trial testimony from Caption Call's expert that it said contradicted Caption Call's expert's testimony that it gave during the IPR. Ultratech moved to supplement the record and tried to do that, but it neglected to get the board's permission to supplement the record. And for those of you who practice in front of the PTAB, you know that's kind of a fundamental mistake. So the board expunged both the motion and the evidence. Ultratech went back, okay, we're very sorry. Can we please have a conference call? We want to move, we want permission to move to get this evidence into the record. The board held the conference call. It was not transcribed or otherwise put into the record. The board refused to review the allegedly contradictory testimony and just heard arguments about why Ultratech should be allowed to move for permission to supplement the record. The board said, the board denied Ultratech's request. It said, no, we're not even going to allow you to move to get this into the record. Oral hearing followed, final written decision followed, and the final written decision relied heavily on Caption Call's expert. cited to its expert over 30 times, and sometimes credited Caption Call's expert over Ultratech's expert on the very issue that Ultratech alleged that there was inconsistent testimony during the trial. Ultratech moved for reconsideration of the final written decision, including for the evidentiary issue. The board denied that. Then Ultratech twice moved to supplement the appellate record to get in the email that it used to request the conference call with the board, and it wanted to supplement the record with some sort of memorialization of, its effort to get this evidence into the record. And at every turn, the board said, "Sorry, we're not going to hear this." Well, come to appeal to the Federal Circuit, you can see that the court was not happy with the way that the board conducted itself here, and said that it was just no reasonable fact finder would not want to hear this allegedly inconsistent testimony. So not only that, Judge Moore went further. She said that that what happened here highlighted a number of problems with the board's procedures with respect to evidentiary issues. It said that the board first lacked the information necessary to make a reasoned decision, because it refused to even look at the evidence before deciding whether it should be admitted. Second, it said that the board's procedures allowed it to make significant evidentiary decisions without providing an explanation or a reasoned basis. After the conference call, the board said, "We'll put out an order saying why we denied your request to move to put the evidence in." The board never put that order out. And ultimately, the court concluded that the board's procedures impede meaningful appellate review of agency decision-making. So this case is a very good case to learn the steps that you need to be taking over the course of the trial to preserve these issues on appeal. Ultratech did a good job doing that, and it highlights the challenges that people face in front of the board with respect to evidentiary issues. So again, I commend you or ask you to look at Ultratech if you're supervising people in IPR proceedings. So we're getting to the end of our hour. We have about 2 minutes left. Mike and I don't see any questions right now teed up in the chat box. So what I think, Mike, we should do is kind of skip the last section here. This slide with the summary of key 2016 decisions, we wrote this up last year. We will send all the participants a PDF and get it posted on the website again. These are significant decisions from 2016. And we're going to end with some stats from the Federal Circuit. And I think we can get through these in about a minute or two.
Yeah, so I mean, the key takeaway is that these cases are swamping the Federal Circuit. You see the black line there, that's the number of cases that are coming out of the PTO, and they're basically all PTAB decisions. And this is the first time that the PTO decisions on appeal are greater in quantity than those out of the district courts. And so the point of this slide, and essentially the rest of these slides, is that this has now become a fully mature portion of the Federal Circuit's docket 5 years in, that the Federal Circuit is paying attention to them, and that it is issuing serious opinions about these cases.
So this chart shows the number of appeals that opened. You can see the ramp up. They're tailing off a little bit, it looks like. I think that's to be expected as we get a greater body of case law. Maybe some issues have been resolved that maybe once appellants wanted to challenge on appeal. People are seeing how difficult it is to take cases on appeal, so the number of appeals opened have dropped. Interestingly, the court added 1 day to its court week to deal with the increased workload coming out of the PTAB. So the court sits the first week of every month, and then they tacked on a Monday after that to deal with the increased workload. Here's the time from the joint appendix to the notice of calendaring. This is how long it takes you to get to the oral argument from the time that the briefing is completed. We've seen a slight climb in that from 2 months up to about 3.5 months, 4 months, probably 3 to 4 months. You can expect your oral argument. Let's see, I accidentally went too far here. One thing I wanted to highlight, if you all are familiar with the Federal Circuit's practice, Rule 36 summary affirmances. This is where the court just issues a per curiam, one-line summary affirmance. It's immensely unsatisfying as a party to an appeal, especially to an appellant, to get a Rule 36 summary affirmance without any indication of why the court didn't go your way. And there, frankly, was a lot of discontent voiced in the patent board with the number of these IPR proceedings that were getting Rule 36 summary affirmances. And I think the court listened to that feedback and that criticism, and you can see the number of Rule 36 summary affirmances steadily falling. I will note that what they've been replaced by in many cases are 3 to 6 page non-precedential opinions that the court can put out very quickly, or the panel can put out very quickly. So at least you get some idea of why the court ruled the way it did. And those are, I would argue, certainly better than a Rule 36 summary affirmance, but I think that's the way they've been able to maintain their docket and not, respond to that criticism.
Well, it looks like we're at the end, or we've hit two or three, but I'll just move to the end. We are happy to discuss any of these issues with you further detail. If you have any questions later on, you can reach us, and we're always happy to hear from both in-house counsel and others who have questions about what the Federal Circuit's doing in IPRs.
Yep. Thank you very much. Hope you found it useful.